May it please the court, counsel, good morning. My client, Auto Owners Insurance Company, had standing before the district court because we had a direct stake in the outcome of that case. In Godfrey versus State, the plaintiff had standing because he used the courthouse. Here, we use the market, the Iowa Workers' Compensation Insurance Plan, the residual market, the assigned risk pool. Indeed, we are required to participate in that market. If you want to write workers' compensation insurance in Iowa, you must participate in the plan, either as a contract carrier, a servicing carrier, or a pool funder. So under 515A.6 then, insurance carriers must cooperate with each other and NCCI in terms of the administration and maintenance of that plan, and we do so under the supervision of the Iowa Insurance Commissioner. The legislature has never restricted the jurisdiction of the commissioner. Indeed, the commissioner is charged with regulating and supervising the business of insurance and enforcing all laws regarding insurance. And the laws in this market include the NCCI standards and the NCCI manual rules. We're here to talk about the commissioner's October 28, 2014 letter to us and to the insured HDR regarding their complaint. And in that letter, the commissioner's investigators said, we've looked at HDR's letter, we've looked at the carrier's response, and we've looked at this complaint that HDR filed in district court in Minnesota, and held first that the division as a state agency does not have authority to resolve this factual dispute. Number one, this wasn't a factual dispute. Auto owners and HDR agreed on the salient facts. We canceled their policy because NCCI told us to do so. The question was that cancellation proper and lawful? That is an issue of law. In Travelers versus Commissioner of Insurance, which was the appeal out of the Action Moving case, this court recognized the authority of NCCI, the administrator of the Iowa plan, to adopt and promulgate rules and standards, and that those rules and standards govern the conduct of plan participants, which includes us, insureds, and producers. The issue in this case was, were those standards and rules regarding cancellation properly applied? And that's a question of law, not fact. But even so, second, this court long ago recognized the authority of administrative agencies to settle important factual questions. In fact, not just recognized it, but encouraged and deferred to it. I'm thinking of cases like Reedy versus White Consolidated Industries, which was then applied by the federal courts in Gilbert versus Constitution State Services.
The counsel, I see a difference between maybe they had the power to step in and decide, but did they have to do it?
I believe they did. And that's the second case I want to talk about, and that's the Franzen case. In Travelers versus DJ Franzen, which was, the opinion came down October 29th of 2010, this court said that that dispute should have gone to the commissioner following NCCI as part of the administrative review process, exhaustion of which was required prior to, in that case, defending against our suit for collection. But the dispute in that case was factual. What was it? Were Franzen's drivers independent contractors, or were they, for purposes of workers' comp insurance, employees such that their payroll should be included in that we use to calculate premium? This court also said in Franzen, NCCI acts as an arm of the Iowa Insurance Commissioner and in an administrative manner. And so an insured that has a dispute with its carrier, as here, must go through the administrative review process, which begins with that dispute resolution procedure described in the NCCI Basic Manual, Rule 4A3G, and then continues on to the commissioner, and then, of course, to district court on judicial review, and then the appellate courts as needed. The second finding that the commissioner made in that letter was that the proper forum for this dispute is a court of law, and that's where the matter now resides, because indeed it did at that point. They had filed suit in Minnesota first. Now, sure, eventually these disputes end up in court, but that's not where they start. In their brief, the commissioner says that nothing in 515A.9 or any other provision of the Iowa Code grants the commissioner authority to resolve this dispute, but that's incorrect. 515A.9 has 3 general requirements. First is that carriers and NCCI must provide written information to insureds who request it. That happened here. There's an email in July, I think it's July 20th of 2014, where Stacy Deaver of NCCI told the insured what the situation was, what rules applied, why their coverage had been canceled, and what to do about it. The second requirement in 515A.9...
Has the insurance division exercised authority to get involved in these kinds of disputes before?
Yes, indeed. There were the action moving cases. There are other cases that I've addressed in my brief that were actually cases of this nature in which I represented the insurance companies when Commissioner Susan Voss was our insurance commissioner. So there certainly is precedent for that. And I also, by the way, cite cases in Nebraska where the plan is very much the same as it is in Iowa, with one exception, and that is in Nebraska there's only one carrier that services the plan, and that's Travelers, but everything else is the same. And so I brought in some cases from Nebraska where I've done the very same thing over there.
How has your client been harmed by the insurance commissioner's failure to step in and resolve this?
Well, I'm glad you asked that question. Going to Judge Hanson's order at the end, when he said, and he was discussing that injurious effect element or the component of the standing test, he correctly noted in his order that the fact that HDR filed a suit in Minnesota wasn't attributable to the commissioner, and that's true. But what is attributable to the commissioner's actions is the fact that we were denied our right to assert failure to exhaust administrative remedies in that case. And here's how that all happened. Had they filed suit in Iowa first, okay, in other words, they went to district court, and I suppose it would have been Kossuth County because that's where they're based. Let's say they filed their lawsuit there without going to NCCI and the Iowa Insurance Commissioner, we would have moved to dismiss that case on failure to exhaust grounds, using it, of course, defensively as opposed to offensively as we did in Franzen. That's what we would have done. We were barred from doing that in Minnesota because by the time the Minnesota case came up on our motion to dismiss for lack of subject matter jurisdiction, that was in November. And in October, the commissioner here had already said, I'm not going to touch this. So what ended up happening was, at the end of the day, a Minnesota district court was vested with primary and original jurisdiction over a dispute that should have gone through the administrative channels here in Iowa.
Let me try and cut through this. So your position on standing and harm is that the insurance commission should have resolved the merits of the dispute, and because they didn't, you now have to defend on the merits in a lawsuit in Minnesota. Is that right?
Well, it's not that we had to defend on the merits, and we did. That's certainly a consequence of what they did. I think it comes down to this. We, as an insurance company, have an obligation to ensure that the Iowa Workers' Compensation Plan is properly operated and maintained. That's our vested interest in this, and it is beyond the interest of any other non-workers' comp insurance company, and certainly beyond the interest of the general public.
But that's not, I mean, there's often administrative orders that do not aggrieve a party that use rationale that the party might not think is optimum. I mean, ordinarily that's not a sufficiently concrete injury, I don't think. It seems like you are asserting a concrete right, if you will, to have the Iowa Insurance Commissioner resolve your issue rather than a different forum. I couldn't find cases that support that proposition.
I'm not saying that they should resolve it rather than the Minnesota forum. I'm saying that the law in Iowa is if you have a dispute between plan participants, an insured, and an insurance company, the law of this state is that that dispute is first presented to NCCI. In 515A.6, remember I said, or 8.9, there are 3 requirements in there. One is that we provide written information to the insured. Number 2 is that we are required to provide a process by which disputes are resolved. And number 3 is if the insured remains aggrieved after the first step of that procedure, and that's NCCI review, they have a right to appeal to the commissioner. It's in the statute. It's in that statute. So I'm not saying the district court doesn't get to act at all, but there's a time and a place for everything.
I mean, does the record indicate what happened in Minnesota?
it is public record what happened in Minnesota.
Because it seems to me if you won your case on the merits, maybe this whole thing is moot.
Well, since you asked the question, may I answer it? And I'll tell you what happened in Minnesota. The case proceeded as summary judgment. Those motions were heard cross motions on October 15th of 2015. We did indeed prevail on HDR's claim for breach of contract and first-party bad faith, but they had a count 2 in their complaint, which was a request for a declaratory judgment that Iowa Code Section 515.127 prohibits the cancellation of an in-force policy that has been enforced for more than 60 days unless that cancellation is for non-payment of premium. I said, that is true. However, the NCCI Basic Manual Rule defines premium very clearly as premium on this policy or any other policy, even if it's written by another carrier. And that's why we canceled them. And in ruling on summary judgment, the trial court in Minnesota granted summary judgment to HDR on count 2, finding a statutory conflict between the Iowa Code section and the NCCI manual. And in doing that, she said, I think the Iowa legislature intended the term premium to mean premium on the current policy only. So we appealed that. We took a certified question appeal to the Minnesota courts. I asked them to send it here to be answered. They declined to do so, and in fact, yesterday, I argued the certified question appeal to the Minnesota Court of Appeals in St. Paul. So that's how the Minnesota case resolved, and of course, we're awaiting an order in that one.
But at this point, as Health Dimensions, they're canceled, you don't owe them money?
Well, we had canceled them and issued them a premium refund, but as the case stands now in Minnesota, because of the trial judge's finding of the statutory conflict, inherent in that order is that our cancellation was wrongful. If the term premium in the Iowa statute means only premium on the current policy, then I guess we shouldn't have canceled them. We shouldn't have done what NCCI told us to do, which of course puts us in an untenable position. I mean, what do we do next then? So there is still out there a determination, at least by this Minnesota court, that the cancellation was potentially wrongful because we canceled for premium on another policy, even though that's what the NCCI rule
So there's
says we're
this
supposed to do.
uncertainty whether the insurance is in place or not. Has there been a claim? Has any worker made a work comp claim?
I'm not aware that any claim has been made, and in fact, that question came up yesterday. But of course, the problem for us would be if that Minnesota order stands, if an injured worker were to present a claim with a date of loss after July 4th, 2014, because that's a date of cancellation, under that Zomer case, we could arguably be held responsible for the payment of benefits. Because, of course, in that case, the Supreme Court said the work comp commissioner has the equitable authority to reform a policy to provide coverage and benefits even when none would otherwise exist. So it is possible that a claim could come in with a date of loss after July 4, 2014, and the Iowa Workers' Comp Commissioner would tell us we have to pay benefits to that injured worker by reforming that policy.
If you win your appeal, is this Iowa case moot?
No. Because the appeal there is there a conflict between the Iowa statute and the NCCI rules? I argued it is not. The Iowa statute is one of general applicability, but there is a more specific rule that applies to this market specifically, and that is the rule that defines premium as premium due on this or any other policy, even if written by another carrier. So in my view, is a whole separate issue.
But isn't your goal to end the uncertainty and have it determined that your policy is terminated, you don't have coverage, and if you win your appeal in Minnesota, haven't you accomplished that mission?
Well, yes and no. I mean, in our view, the cancellation was proper. The trial court did find that we did what we did because we were told to do it, so there was never a finding of liability as against us, but we felt it very important to get that certified question resolved. The issue here, though, that we need to have resolved is for this court to take what it did in Franzen and expound on that and say, look, you decided in Franzen that this administrative review process is mandatory. If it's mandatory, it's mandatory. Because again, I come back to, what if, let's take Minnesota out of the mix. What if HDR started its dispute resolution process against us by filing suit in the Iowa District Court for Kossuth County?
Chief, could I ask just one more question? I just want to explore the mootness a little bit more. What if you end up hitting a home run in this appeal, all right, and we reverse and say you had standing, and we reverse and say the insurance commission should have reached the merits of the dispute, which is your position? What does that do to the Minnesota judgment?
I don't think anything, because again, the Minnesota judgment was in our favor on the substantive claims. And to the extent that it disfavored us, it was on the statutory construction issue only, and there was never, ever a finding of liability as against us. In fact, the trial court said there can't be any breach of contract here, nor any bad faith, because auto owners did what it was told. All right? Thank you very much, and I appreciate the little additional time.
Thank you as well, Ms. Ibson. Ms. Esbrook.
Thank you, Your Honor. May it please the court, counsel. So the only issue on appeal today before you is whether auto owners had standing to seek judicial review of the insurance division's decision not to investigate or prosecute them based on the complaint that their former insured made.
But here's where I have a trouble on your standing argument. Mm-hmm. So let's say Health Dimensions had appealed, and they would certainly have standing, right?
I'm actually think it's kind of unclear that they would.
Well, they would be aggrieved if they had a complaint, right? And you didn't take action on it, right?
Possibly, but there's a case that from several years ago that said that if someone makes a complaint, this was a licensing board, the Board of Educational Examiners, that the case was reviewable in federal administrative procedure. Such a decision, which is essentially prosecutorial discretion, is not reviewable. It's just taken out of the category of things that were reviewable. But that's what's only been answered. Whether
right.
They are actually aggrieved by that, I don't know if that's clear.
That's a different issue. That's sort of, there are certain actions that
right.
are just not administratively reviewable. I go to the county attorney and ask them to prosecute someone, and they decline. I can't
right.
appeal that.
I think it's like that.
But that's different from not being aggrieved or not having standing. And my concern is that if the other party would have standing, why can't auto owners come before us and say, well, we're aggrieved too because we think that the insurance commission should have gotten into this dispute and handled the merits. And by not taking action, they are leaving us to this other litigation forum that we don't want to be in.
Sure, Your Honor. I mean, in assessing standing, the focus is on the party, not the claim. So you do have to look at HDR and auto owners separately when you're looking at standing. And so they're in the same position that they were in, which is not being sanctioned by the insurance division, which is what would happen. The insurance division was treating this as, we think that our insurance company has acted unlawfully, and they decided not to pursue that. So they're not aggrieved. Nothing's happened to them. They're not facing a licensure sanction. They're not facing a fine. I don't know of any cases holding that such a person is aggrieved and can ask for judicial review. They don't like the reasoning that we came to, that the division came to, but they're not injured by it.
Well, maybe they lost the ability to go to Minnesota and waive a decision on the merits in front of the judiciary in Minnesota.
Yeah, a lot of the conversation here seems to be based on the fact that we didn't tell Minnesota courts what to do, but I think that they're claiming injury based on something that I'm not sure the division can do. The auto owner certainly could have said in Minnesota and did say there's an exclusive process. It's not just exhaustion of remedies, but then judicial review is your exclusive remedy, and that's what you should be doing. Minnesota didn't agree with that. They rejected that argument. We can't tell Minnesota what to do. That seems to be the basis of their injury, that they were forced to litigate a claim in Minnesota, but I don't know if injury for standing can be based on something that is just not within the statutory or power of the Iowa Insurance Division. So yeah, as I said, the summary of the situation is that Health Dimensions Rehabilitation filed a complaint and that auto owners had improperly canceled its workers' compensation policy in a way that violated Iowa law. So potentially a complaint like this could lead to a penalty for auto owners, a sanction on its ability to sell product in Iowa, and then the division declined to investigate or prosecute further.
I take it was other agency action.
Yes, I absolutely agree that this is agency action and that they have an interest that is, there's two parts to the test, right? So they have to both, have an interest in the outcome and an injury. I think they were asked for their opinion on it. They filed a response to the complaint. I don't think I could say they're just like the general public. That's not true. It's just that there's no injury that would support the case. So I think they're arguing they were prevented from defending themselves in Minnesota the way they would like. And so either HDR did exhaust by filing this complaint, in which case that argument, I think, would be gone for them either way, or HDR did not exhaust, and then they could still pursue that. But either way, it's not something the division did or didn't do that caused their injury. In federal law, which is persuasive on the court, it's not, I think, technically part of the standing test that you look at here, but there are cases where you say federal law and standing is persuasive. Part of the test there is that the injury needs to be remediable by something that this particular agency did.
Well, and you could have remedied it by either declaring as a matter of law the cancellation was appropriate, or if there was a factual dispute, resolving the factual dispute.
Yeah, so I think that is the first part of that, I think, is partly what they're looking for. They would like an explanation of the law and like a certificate of good conduct.
I'm
but
sure they
that's
would prefer a ruling on the law rather than a factual
right.
dispute.
So they could have come to the insurance commission and asked for a declaratory order explaining the law. It seems like that in their view, there's a lot of confusion out there that is troubling and causes uncertainty for their business. That's certainly something that is available. And I think I would have to concede that if they had done so and they wanted to bring the insurance commissioner's interpretation of the law to district court and ask for judicial review of that they could have done that. I think they could do that now. But that's not the situation that actually took place.
Kind of interesting. I think you maybe concede they have standing to bring a declaratory action of some kind to get the law clarified.
Sure.
But they don't have standing to get the same clarification in the context of this other agency action.
I think that's true, Your Honor. I think they don't have standing in this particular case with this particular party. They're complaining about an injury that happened to somebody else. And the injuries they're complaining about have to do with the litigation in another state that essentially the division doesn't have any power to control or change.
I mean, as Justice Appel said, I mean, now that may be the case that there's no power, but initially, if you, like Justice Appel said, if the commission had reached the merits and issued a favorable ruling for auto owners, that could have been waived in front of the Minnesota court and would presumably have aided auto owners' position in that court, right?
Well, I think that's where there's kind of a misunderstanding of the agency procedure that was actually happening here. The only two possible outcomes of this complaint were no action, which is what they did, and they explained why, but they could have, I think, said there's no probable cause to think that a violation of Iowa law happened here. That's often the response of an agency to a complaint. Or a sanction. You know, we go through a procedure, we file charges, we have an administrative hearing, and then there is some kind of a sanction on their license, a civil penalty often will be the case. An explanation of the law and an agreement that nothing wrong had been done, what they're looking for is not they don't say, we're not going to press charges, oh, and we think you did everything right. That's not part of really agency procedure.
But I mean, even that no action might have been helpful to them, right?
Well, that's what they had, right? They had this thing saying we're not going to do anything with this. And so they can bring that to Minnesota and say, HDR should be asking for judicial review because that is their exclusive remedy. HDR never asked for judicial review, and that might actually be helpful to them in another litigation to say, you're foreclosed. You can't go any further with this. If this is your exclusive remedy, the problem is Minnesota didn't agree that Iowa process was exclusive, and we can't change that.
Would add more than that, if it would have been actually litigated, if there would have been a factual determination made, or a ruling on the merits of some kind, then they would have been in a position to say preclusion. And here, where the commissioner punted, they were not in a position to assert preclusion, it seems to me, right?
I mean, I think we can all agree that they preferred to be in Iowa, and they preferred that the
No, they
agency
prefer-
take this.
they-
This would
they
be
prefer
better,
to
and then
have
they
a-
could have used it in Minnesota.
Yeah,
Right.
they prefer to have a preclusive order from an agency that either ruled in their favor as a matter of law or decided the factual issues in their favor. Then they could go up to Minnesota and say, it was actually litigated, it was actually resolved in the merits. Obviously, they couldn't do it under the state of facts.
But they did not have a preclusive order from Iowa, that's true. They did not.
If we reverse and say there was standing and that the action should have been taken, is that going to create problems with the agency?
No, I don't think so, Your Honor. We would go back to the district court. The district court, as I'm sure you noted, did not make any ruling or decision on the merits of, whether there was something arbitrary or capricious or improper about the division's ruling. And so I assume that you could send it back, and then that would be the conversation that we would have at that level. We just maintain our position that there's no standing, and there's really nothing that would support them bringing this before the district court. There's several cases, I think, that we discuss in our briefs that talk about what kind of standing you have to have, what kind of injury you have to have. I think the Polk County versus Iowa State Appeal Board shed some light on why there's no standing in this case. The court said specifically that only taxpayers whose particular interests were affected by the budget reduction actually had standing. So just people who had been part of the process, apparently there's some kind of process.
Well,
before the
maybe
State
so,
Appeal Board.
but they're not, they're really not here as a general member of the public.
No, that's true. And I think I maybe should speak a little bit about, this kind of goes a little far afield from standing, which is where I think the argument should be, but I think there's some disagreement about my client's position. The insurance division's position is that this is just a complaint of misconduct. And their position is that we were required by Iowa Code 515A to treat this as an appeal from NCCI. If you look at the statute, it talks about ratings disputes. Those are the kinds of disputes. That's the kind of dispute that the insurance division has expertise on. We have actuaries, we approve rates, we talk about rates and risk. The insurance division does not need to under that statute and doesn't deal with questions like this, where I say you canceled me improperly and you say I didn't. That's not a rating dispute. It's not a premium dispute. If you look at the Franzen case, it talks about that particular section and kind of goes a little bit farther than the statute does in saying that premium disputes, as Ms. Ibson described, this person is wrongly qualified. They're actually an employee, not an independent contractor, so they should be included in the premium calculation. They considered those as related to ratings questions, and so that they also fall under that statute. And so you do have to go through an administrative review. This is, as far as the insurance division was concerned, not a ratings dispute, not an appeal from NCCI, not something they had any expertise in resolving. And so that's why they treated it purely as a complaint of misconduct under the rules that govern the selling of insurance in Iowa. I want to make sure that was...
What's your position on mootness?
I'm sorry? Oh, mootness. Oh, yes, thank you, Your Honor. I think, and since Ms. Ibson brought that up, it's not in the record, but I think you can take judicial review of the status of the litigation in Minnesota. The HDR took and cashed the refund check that they were sent by auto owners, accepted that their policy, that's the source of this whole dispute, was canceled. They consider the litigation over. They did not appear in oral arguments that took place yesterday. So I think that case is moot. And so in a lot of respects, this case is moot also. The dispute between these two parties about whether this policy should have been canceled and and how much they should have paid for it is concluded. Thank you. Unless you have any other further questions, I think I'll sit down. Thank you.
Thank you as well, Counsel. Ms. Ibson.
Thank you, and again, may it please the court, the question was presented, would HDR have had standing to appeal on judicial review of the commissioner's refusal to hear their complaint? And of course, the answer to that question is yes. Why didn't they? Because they didn't want to. They wanted to prosecute their case directly in a district court, and they wanted to do that in Minnesota. And the effect of the commissioner's refusal to discharge its duty under the statute then allowed HDR to circumvent our laws and avoid our administrative review procedure and go directly to district court in Minnesota. In argument, the
Can we
commissioner's
take
attorney-
judicial? Can we
I'm sorry?
take judicial notice of those Minnesota proceedings?
Yes, I think you can. I wish the proceedings had been referred here. That certainly would have simplified things quite a lot, but for whatever reason, the Minnesota Court of Appeals wanted to answer that certified question.
And the refund check has been cashed? I mean, that's another interesting, I mean, that isn't in the record of the litigation, but we just heard it
Yes.
today.
So the refund check was cashed after the case had been concluded in Minnesota.
But well, what does that have to say about? I
Well,
mean,
right, so we talked about that, we talked about that yesterday too, because what happened was, we filed our notice of appeal. Again, remember, it's a certified question appeal. We're not arguing anything about the merits of the case because there was no determination of liability adverse to auto owners.
I know, but the dispute over this policy seems to be rather moot in light of what I'm hearing. The refund check has been accepted. They're saying, okay, fine. You now have a appeal of some kind of Minnesota pending, but the underlying dispute regarding your cancellation of the policy appears to have been accepted by HDR when they cashed the check.
Well, that's the argument HDR made, certainly. And by the way, they didn't file a brief. They sent a letter to the clerk of court, and the court asked me to address that. But remember, again, we have a court order that says that the cancellation was she doesn't say it was improper, but she says that there's this conflict between the two, and maybe we shouldn't have followed the NCCI rules. That's the only subject before the Minnesota Court of Appeals. And again, also, even though they cashed our check, let's go back to the hypothetical we talked about before. What if a claim comes in with a date of loss after July 4th, 2014? Hypothetically, the workers' comp commissioner under the Zomer case could reform that policy and say that in fact it does provide benefits for that injured worker because the commissioner has the equitable authority to do that. So then what do? We've got a policy that apparently continued after July 4th, 2014. Despite our cancellation of the policy, we are now ordered to pay benefits under the policy. And at that point, I guess we have to go back in, we issue another policy, we do a final audit, and we try to collect our premium back.
That sounds very speculative to me. Do we need to issue an advisory opinion just because that might happen, or can we all just go home and wait, and if there's a claim, then you assert the defense of proper termination and take the appeal up if you lose?
And that's, I'm not asking for an advisory opinion. I think we've gone a little off course here. But, is it a hypothetical? Is it all kind of it could happen? Well, sure, but that, really is the nature of the whole business of insurance. I mean, that's what we do, is anticipate risk and anticipate claims. A couple other points I want to make is that, as I understood the counsel's argument was that HDR did exhaust its administrative procedural remedies here because they filed this complaint with the commissioner, and the commissioner declined to hear that. That is not an exhaustion. Let's remember, too, one issue we haven't talked about is burden of proof. So the way this all works is that the carrier makes a determination, and then the insured appeals to NCCI, and they have the burden of proof. And if they're unhappy with NCCI, they appeal to the commissioner, and again, they have the burden of proof. Okay, it's the same reason why we didn't go to the commissioner and ask for some sort of declaratory judgment. Why would we? The burden isn't on us. We did what we thought we were supposed to do, and if our insured is aggrieved, then they prosecute the appeal because they have the burden to do so. If, the other thing that Commissioner's attorney mentioned was the commissioner could have issued a finding of no probable cause to find a violation of Iowa law. That would have been swell. That I could have used in Minnesota, but we didn't get that either. 515A.9 applies not to, in the Franzen case, applies not just to premiums and rates, but to application of a rating system. That's what the plan is. The rating system we are talking about is the Iowa Workers' Compensation Insurance Plan or the assigned risk pool. And finally, I'm out of time, but the point was also made that this case could be remanded back to the district court. I submit it doesn't need to be. This court could say, look, the commissioner should have done this. This is part and parcel of the administrative review process that we've already found is mandatory for disputes in the residual market, and that can then.
You want us to treat it like a declaratory, an appeal of the denial of declaratory relief, I guess.
Well, I'm saying you can do either or. You can remand it back to the district court with findings consistent with your pronouncement, or you can just make the pronouncement.
And they did dismiss it as moot, probably. I don't know.
Well, they might. Anything further? Thank you very much. I appreciate your time this morning.
Ms. Ibson, thank you as well. The case then is now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.